The petitioner, Bianca Blair, appears by Zoom in person, and also her attorney, Ms. Lauren Schooler, appears with her and on her behalf. The respondent, Joshua Blair, continues to be pro se. This is a divorce case with 4 children. It's been ongoing for quite some time, since July of 2024.
Part 1. Courtney Record Par Note Kia Ki Divorce Case July 2024 Si Chow Raha Hai, Char Baki Hain, or Father Barbar Court Appear Nahi Ho Raha. Judge Pale Use Time Dia Ki Apni Job or Finances Stable Care, is Liga Si Cam Child Support Lia Ya Raha Tha. Lekin Ye Relief Temporary Tha, Permanent Nahai.
Frankly, Mr. Blair an opportunity to get caught up with his life situation, his employment, and he literally was paying half of the child support that he probably should have been paying. But he got an adjustment for his financial circumstances to get on his feet. During that time, he had another child with a woman he's living with who has other children. He's consistently claimed that he can't afford child support. The court's tried to explain to him child support's not based on what you owe, it's based on what you make, and your first priority is to your children. This is legislatively mandated. It is supplemented by Supreme Court rules. Speaking of which, there are some new ones in July. Did they have any effect on this case at all that you're aware of, Ms. Schooler?
No, not to my knowledge, no, Your Honor.
Okay.
Father Ka main argument Yethaki Wo Child Support Afford Nahai Kar Sakta. Judge Seed Hai Bat Kai. Child Support Tumher Bills Par Nahai. Tumhari Earning Capacity Par Hodi Hai. Or Tumhari Paley Zimidari Tumher Bake Hain. Naya Child Hona Yanei Family Banana Purain Bakan Kai Responsibility Cam Nahai Karta.
But I indicated to him I would review it in a year. And that once we had a working child support worksheet, which Ms. Schooler has submitted, that it would be adopted and we would have to follow the guidelines like everyone does. And I scheduled it for hearing today. I did reset it because he is allowed to include his new child as a multiple family, perhaps even by discretion, but at any rate, I asked that be done. There was also a request for a judgment in the amount of $1,472. I asked about submission documentation of that amount. It was for me and to make sure he got sent, but I am not going to withhold granting that judgment. If he wants to file a motion to reconsider or a motion for modification or clarification, if he finds something erroneous, that's fine. I did note Ms. Schooler, and of course, Mr. Blair does not appear. He's previously not appeared. He complained about the judge entering, which is me, default judgments previously when he failed to participate and appear when he was present when the case was scheduled for hearing in front of me. And I tried to explain to him that's how it works. If there is a motion or request, as long as I view it's in the children's best interest, it's granted. even by default, when there's a lack of participation by a parent or a party. People get divorced by default. So they certainly can have modifications by default. So, and I've been provided by an extensive notebook by Miss Schooler the financial information. I did note, though, she was concerned that she had some transmittal difficulties sending him each and every bill. It didn't, all the attachments didn't get submitted, but she has since then recognized that and resubmitted them. So they were for me to know that she reviewed the documentation of the judgment, that it was available for me to review, and that he had copies of it. And all of those things have taken place. So, Ms. Schooler, I know you were expecting that you might have to seek a continuance, as what you mentioned to my AA early this morning, but I just don't think that's necessary. In looking at your notebook and what you have submitted, I have no reason to believe that there isn't documentation supportive of a $1,472 judgment for the children's needs, medical needs, etc. When there are 4 children and glasses cost at least $400 a pair. So at any rate, I'm also going to adopt your proposed worksheet.
Your Honor, may I briefly interrupt?
Sure.
As you noted on the record, my transmittal difficulty, there's also a slight, a discrepancy on the child support worksheet that I submitted. Clearly math is not my strongest suit, and I did supply the documentation to prove my error. I have the amount of health insurance that Miss Blair pays every month at $249. It's actually $454. I think I did not double it like I should have for the $249 around what she pays per paycheck, not per month. And I have all that information in my notebook to you. If you want me to have her testify to it briefly, she pays $209.90 per paycheck for dental, vision, and medical for the children. That's not covered by her employer. And she is paid bi-weekly. And when you do that math, it comes out to $454.78 a month that she pays.
All right. You do know, though, what you're supposed to do is take a single plan, unless it's offered free, and deduct out what she's paying for her own coverage.
Right.
So single plan rate, and you take a family plan rate, and you have to deduct the single from the family.
So what's interesting about that is her pay stubs actually reflect dental, child, medical, child for just the children specifically. So that's where I got those numbers.
Okay.
Because I totally understand what you're saying. I do. Hers is just different. I don't usually see it like this.
Okay.
So those are the numbers that I got from her pay stub.
Okay. Well, I expect that's probably where the insurance industry is at, even in group coverage. So are you going to, have you rerun a worksheet with the corrected amount?
I did not yet, Your Honor, because quite frankly, I was preparing to go forward with what it is due to my error or getting a continuance. I can quickly run one if my paralegal's here, but I know I'll probably have to submit this.
Well,
or maybe not Rule 170 since he's not present.
Mother Key lawyer ni medical expenses Key le $1,472 ka judgment request Kia. Father court main Majud Nahai Tha, Lekin documentation complete Thai. Judge ni Kaha Key glasses, medical care, or basic needs char bakan ki le mangi hodi hain. Is le judgment approve kia gaya, bina delay ki.
Well, it's up to your client. I can adopt the amount that you proposed, that you sent the worksheet to him as your request, or I suppose you'll have to send him a new modified one and we reset it. I'm not going to grant by default something he hasn't seen or he's not aware of.
Bianca, do you want to, it's off by $200, $205. We can reset it and I could submit a new worksheet, or we can go with the 1,400 that I've already submitted to the court. And I will do whatever you want to do.
It's fine the way it is. I don't have much faith I'm going to get what I'm asking for as it is, so I don't need to push it any further.
Okay.
Just out of my own curiosity, what is the percentage split? Is it 40, 60, 50, 50, 55?
It is
45.
52 actually for Mr. Blair percent, 47 or 52.4 for him, 47.6 for her.
Okay. So even at 50-50, you're talking about it would be an additional amount of probably 102.50 is what it would probably work out to.
Yeah.
I'm happy to do either. I indicated to him, and this was my plan, I believed it was very important to get this case in a posture that it's removed from my court docket, because every time I review the case, it's basically an argument with him. It's a new issue. It's things that aren't briefed. It's things that aren't with notice. You know, I can't have ongoing hearings where there's no motion on file to support the requests. And that happens a lot with pro se.
Child support worksheet main ch hodi c math error thigh. Lekin judge ni clear kia ki jo worksheet father ko pale beji yachuki thigh. Wahai adopt hogi. Court ni final child support $1,410 per month approve car dia. Retroactive date September 1 set kai. Reason simple tha. Case co final posture main lana zarari tha.
Parties. And there needed just to be some finality to this so that future modifications require some justification or, a substantial enough change to where it could be set consistently. So I'm going to approve the $1,410. That is his child support amount as of today. So that will be, I don't know what to do about the retroactivity. What was did your request or motion include a requested start date?
Let me get to it.
Or are we looking at November 1?
I do not believe I included a start date, Your Honor, but my motion was filed July 22nd.
Okay, we'll make it September 1st then.
Okay.
August 22nd would be 30 days from the filing. We'll just go up to September 1st.
Okay.
Okay. And I'll put on here as of September 1, 2025. Okay, and the judgment is approved. Now, with regard to any future visitation, any future visitation shall involve SoberLink. Are you familiar with that? I guess that's a new thing that Sedgwick County uses.
I have not heard of it, Your Honor, at all.
And it's a call-in breathalyzer program. So if visits become unsupervised at any point, I will want him participating in SoberLink.
Your Honor, so if he files a motion, because I believe that was your previous order, we were waiting on him to essentially do something. So if and when he does file a motion, he shall have SoberLink ready to go, or how would you like me to word that?
Yes,
Okay.
SoberLink needs to be part of any future orders. So I guess what I would tell Ms. Blair is if she gets to a spot where she thinks the kids want to see him, she thinks it's in their best interest, she's going to allow him to have a little time with them on a Saturday or something. I want SoberLink to be part of that. So I would ask or instruct her not to provide any visits, because I am going to allow her the latitude to make those decisions if she views it's in the best interest of the children. Because where we left off was supervised, correct? And he just hasn't paid and done anything through the child visitation center. So
Yeah, he refused.
He still has that available to him, but if at some point she chooses to allow him to see them with outside of her presence, I want a SoberLink to be in place.
Okay. Your Honor, I do have two brief clarifying questions. Because he did not appear, are you still requesting I submit this pursuant to Rule 170? Or no, since I provided him this information back on September 22nd?
We've done exactly what you provided, exactly what you asked.
Okay.
Exactly what I instructed you to do by modifying to give him the benefit of the other child. And so I'm just going to grant it by default. He knows what the judgment would be if he didn't appear.
Okay.
And I actually did the medical judgment conditional. I actually granted it conditional upon proof of services, which has been done by her. She's provided it. So
my final
please make note, though, for future purposes, that the entire amount of the children's health care was not included. So if he files a motion for modification, the entire amount will be allowed.
Okay.
That's not a Ray Judicata issue.
Okay.
That is I am adopting what was submitted and proposed, but I'm not making a determination as to what insurance he should be responsible for.
And then my final question is, I believe at the last hearing or the last time we had a trial, you asked me to issue an income withholding order, and I would request that I be able to do that again in this case. However, he quit his job, which I believe you predicted initially when we filed this motion. So I'm not sure what my question is. Can I still, I guess, issue an income withholding order? I guess, well, I'll just file a motion to issue a new one if I ever find his new employer.
Yes.
Okay.
And then, when he's not paying, then do a contempt citation. And I guess he'd rather go to jail than work. So
some people prefer it, unfortunately.
I did see the emails where he threatened to quit his job because he wasn't going to have enough money. But I want to say for the record, I looked at his DRA. He didn't even add his numbers. What he listed as an amount, the numbers didn't even add up to. there's like $400 listed for pets, which makes no sense to me. I mean, I don't feel like it was a genuine reflection, and he did not actually add up he's got an expense to a gentleman that I don't even know who it is. It's not a lender. I mean, there's so many questions I would have about his DRA that I wouldn't accept it on its face value. So, at any rate,
I think that's all the questions I had, Your Honor.
okay, at any rate, an income withholding order is required by law. So yes, I'm going to approve that one be filed.
Okay.
And hopefully he looks at the literature and realizes that when you're willfully unemployed or underemployed, the court can impute the income that you were receiving when you quit your job without another job in place or a good reason. So it's not a situation where you can just come back and want a new child support worksheet showing that he's not making any income. There are 4 kids to support here, and I feel sorry, Bianca, for you that you're carrying the weight and the load of it. But
Have their whole life. I'm used to it. It's okay.
all right, so feel free to do a contempt citation. If you verified with his employer that he's not working.
No, Your Honor.
Okay.
That's just, so I'm going to send the income withholding order because maybe he was trying to call our bluff. I don't know.
Okay, yeah, do that. Please do that.
Okay.
So,
Judge Ni income withholding order approve Kia or warning di Ki job ch hordina solution nahi hoda. Agar koi willfully unemployed ho, court payly salary key basis par income impute car sakti high. Visitation key le by condition lagai gay. Agar future main unsupervised visits hue to alcohol monitoring system sober link mandatory hoga.